The political battle over the shape of the U.S. Congress is escalating, with major developments in both Texas and California. In Texas, the Republican-controlled legislature is pushing forward with a new congressional redistricting map that analysts say would solidify the party's power and grant it 5 additional seats in the House of Representatives. The Texas House passed the controversial map just yesterday, on August 20th, following the state Senate's approval last week. Governor Greg Abbott has already indicated he will sign the measure into law. This legislative-driven process is a classic example of how the party in power can redraw electoral boundaries, a practice that often leads to accusations of gerrymandering, where districts are shaped to favor one party over another. In a direct counter-maneuver, Democrats in California are taking a different approach. Instead of leaving the map drawing to legislators, Governor Gavin Newsom and state Democratic leaders are putting a competing proposal known as Proposition 50 directly before voters this fall. During a press call this week, Governor Newsom, joined by New Jersey Senator Cory Booker and Democratic National Committee Chair Ken Martin, argued that their plan offers a fairer alternative. The measure has also gained a significant endorsement from former President Barack Obama, who praised the plan as a responsible approach to the decennial process of redrawing political lines. This sets up a stark contrast between Texas's legislative method and California's attempt to use a direct-to-voter ballot measure to shape its congressional representation for the next decade. This clash over state versus federal power and political philosophy is not limited to election maps. It's also at the heart of a fierce, ongoing legal battle over immigration enforcement. The Trump administration has continued its campaign against so-called sanctuary jurisdictions by suing multiple states and localities. The administration argues that policies prohibiting local law enforcement from cooperating with federal immigration authorities are unconstitutional. According to the Justice Department, these sanctuary policies violate the Supremacy Clause of the Constitution, which holds that federal law supersedes state law. President Trump has also ordered the federal government to prepare for defunding these areas, a move that has been met with a flurry of lawsuits from the affected jurisdictions, effectively blocking the order for now. The states and cities counter that the federal government cannot commandeer their resources. They argue that the 10th Amendment prevents the federal government from forcing them to use their own personnel and funds to enforce federal immigration laws, a principle known as the anti-commandeering doctrine. This fundamental disagreement over the balance of power between state and federal governments remains a deeply contentious issue in courtrooms across the country, with no clear resolution in sight. While that broader legal fight continues, a more immediate and personal immigration battle is playing out in the courts, affecting the lives of tens of thousands of long-term residents. A federal appeals court in San Francisco has granted the Trump administration an emergency stay, halting a lower court order that had preserved protections for approximately 60,000 immigrants from Honduras, Nicaragua, and Nepal. These individuals have been living in the U.S. under Temporary Protected Status, or TPS, some for more than 2 decades. The case began when DHS Secretary Kristi Noem moved to terminate their protected status. However, on July 31st, federal judge Trina Thompson blocked that termination, stating in a powerful ruling that the decision was likely driven by racial animus and was a preordained decision that violated administrative law. Judge Thompson wrote, "They are told to atone for their race, leave because of their names, and purify their blood. The court disagrees." Now, the appeals court has paused Judge Thompson's order while the administration's appeal proceeds. This ruling does not settle the case, but it removes the immediate protection for these immigrants, plunging them back into a state of uncertainty. They now face the possibility of losing their legal status and work authorizations, making them eligible for deportation while the legal challenges continue. The Trump administration's assertive stance on national sovereignty extends beyond domestic immigration policy and onto the international stage. The U.S. State Department has announced a new round of sanctions, this time targeting 4 senior officials at the International Criminal Court, or ICC. The individuals named are Judge Kimberly Prost of Canada, Judge Nicolas Galou of France, and Deputy Prosecutors Nazat Shamim Khan of Fiji and Mam Mandiaye Niang of Senegal. According to a statement from Secretary of State Marco Rubio, the sanctions are a response to the ICC's efforts to investigate or prosecute American and Israeli nationals without the consent of either nation. Specifically, Judge Prost was involved in authorizing an investigation into the actions of U.S. personnel in Afghanistan, while Judge Galou ruled to authorize arrest warrants for Israeli Prime Minister Benjamin Netanyahu. The two deputy prosecutors were sanctioned for their continued support of actions against Israel. The U.S., like Israel, is not a member of the ICC and does not recognize its jurisdiction over its citizens. In response, the ICC issued a statement deploring the sanctions as a flagrant attack against the independence of an impartial judicial institution and an affront to its 125 member states. The sanctions freeze any U.S. assets of the officials and prohibit American citizens and businesses from dealing with them. Beyond the realm of international justice, the administration is also engaged in enforcing its economic policies, though American companies say the fight is far from over. A case involving a U.S. pipe manufacturer highlights the persistent challenges in the ongoing trade disputes with China. In 2018, Charlotte Pipe and Foundry, a company that has been in business for 124 years, believed relief was on the way. This practice undermines the intended effect of the tariffs and leaves American manufacturers still struggling to compete. As one executive from the company stated, "You don't stay around that long if you're not determined and willing to fight and compete."